Hey, my name's Ryan Davis. I did my research paper on NIL, name, image, and likeness, college athletes' path to success. So, for decades, colleges and universities across the country, they've sold tickets, merchandise, various other modalities with current and former players attached to these modes of income. So, what that means from video games, jerseys, memorabilia, paper tickets, online and TV advertisements, you name it. There's players portrayed, current and former, with none of them receiving any of the profit that the institutions and the NCAA does as a result of selling this merchandise, selling these video games, etc. So in 2008, a former NCAA player sued the NCAA in a case that kind of began the process of players profiting off name, image, and likeness. This is White v. NCAA. Like I mentioned, it was the first major case of players suing the NCAA for limiting the amount of benefits they were able to receive, and it accused the NCAA of violating the Sherman Antitrust Act, something we'll get into in more length coming up. The next case was O'Bannon v. NCAA. This stretched from about the end of White in 2008 all the way through 2016. Ed O'Bannon, a former UCLA basketball player, sues the NCAA and eventually EA Sports as well. This case was the one that brought name, image, and likeness to the forefront. It again centered on the idea of the NCAA violating the Sherman Antitrust Act. It centered on the fact that EA Sports was paying the NCAA for licensing rights to produce the video games, but the players didn't receive any payment for being in the video games. This case was settled out of court. However, the opinion of a legal scholar after the case, after the arguments had been heard, after it had moved up from lower courts up through the appellate, was that the O'Bannon case had made it increasingly difficult for the NCAA to defend itself in antitrust lawsuits moving forward. So we get to the big one. In 2021, it was NCAA v. Alston. This was a Supreme Court decision, a unanimous decision, in finding the NCAA in violation of the Sherman Antitrust Act. The Supreme Court found, in agreement with the district court and working its way up to the Supreme Court, that the NCAA violated the Sherman Antitrust Act by limiting the education-related benefits schools could offer student athletes, such as limiting scholarships for graduate or vocational school, payments for academic tutoring, or paid post-eligibility internships. Although NIL wasn't directly addressed per se, that's what the case was centered around, and what this case did with this unanimous decision was open the doors for the states to begin passing legislation allowing those student athletes to profit from their name, image, and likeness. Kind of the big quote that comes out of this case was from Justice Kavanaugh in his concurring opinion that he wrote, where he says, "Nowhere else in America can businesses get away with agreeing not to pay their workers a fair market rate on the theory that their product is defined by not paying their workers a fair market rate." So again, kind of touching on the idea of amateurism and the NCAA withholding any kind of payment or allowing players to receive any kind of payment strictly because they were amateurs. So we're going to push back a few slides and talk about the Sherman Antitrust Act. Essentially, it's an act passed to prohibit monopolistic practices. It applies to NIL because the players used the violating the Sherman Antitrust argument because there was a lack of a market in collegiate sports, coupled with the business model that the NCAA has in place, does not allow for players to be paid fairly based off the earnings of the NCAA. So the NCAA makes millions of dollars, players receive nothing except an academic scholarship. But the question again, isn't it amateur athletics? Absolutely. But it doesn't mean players can't profit off their name, image, and likeness. It just means that they can't be paid directly by the entity that they play for. So the NCAA, the member schools, so on and so forth, they can't pay them directly beyond their scholarship. However, it doesn't mean they can't profit off their name, image, and likeness while they're in school. So after Alston v. NCAA, within 2 weeks, 13 states had passed legislation relating to name, image, and likeness. Your usual suspects, Alabama, Florida, Georgia, Texas, California, all the big boys in terms of college sports had passed legislation within 2 weeks, kind of setting the groundwork, the guidelines for what NIL could be in their states. Kind of the general consensus between those was the idea that the institutions cannot directly pay an athlete beyond scholarship, books, room and board, the same idea that was in place. But that players could now obtain counsel, so they could hire an agent for NIL related deals. That the institutions cannot stop athletes from signing name, image, and likeness deals. They can't rescind their scholarship due to it, and the only caveat is that the NIL payments should not interfere with provisions of the scholarship. So as of now, we're up to 34 states that either have name, image, and likeness legislation, or it's in the works, it's been proposed, it's being voted on, etc. So as of this point, at the federal level, they've kind of left it up to the states to decide how they're going to move forward with it. Been some bills proposed, nothing has been passed. So as of this point, it's a states' rights sort of deal. So we get to the question: is college athletics better off than before name, image, and likeness was, legalized, for lack of a better word? My opinion, absolutely yes. Athletes were being paid before, anyways, despite NCAA rules. So now it kind of levels the playing field. It allows these 18 to 22-year-olds to have opportunities they may have never had. It sets athletic programs in colleges up for success moving forward, keeping the athletes in school longer if they have money in their pocket potentially. And 98% of professional athletes or college athletes will never play professionally. So this gives them an opportunity to grow their brand, obtain some wealth, and kind of set up opportunities for themselves post-college. A lot of these athletes, from YouTubers and everything else, they're being given opportunities with name, image, and likeness to profit off of their name, image, and likeness. So with that in mind, have a good night.